We're here for oral argument in 1 CACV 190406, Secura versus Sudhoff. I would remind counsel that these proceedings are being audio and video recorded, so we'd ask you to please identify yourself and your client at the beginning of your arguments. Each side will have 20 minutes. Mr. Abney.
Thank you, Your Honor. Usually I get a longer warning speech to get ready. Good morning. May it please the court. My name is David Abney here, representing appellant Megan Sudhoff. This is one of my typical desperate cases, but maybe not as desperate as usual. The problem is Joseph Gabriel has decamped to parts unknown, and the only thing we really know about what happened at the motor vehicle accident was that his van, a company van, a clearly and brightly marked company van, hit Megan Sudhoff while she was riding her bicycle on Mountain near the University of Arizona Law School, and caused her some serious damage. When the police showed up, Mr. Gabriel said that he was on his way to a job and didn't provide much more information of any use that's in the police report. A few months later, Mr. Gabriel doesn't go into work and just vanishes. We had hired somebody to skip trace him with no results, and I know my colleague across the aisle, my distinguished colleague, he hired people to do it, and nobody's been able to find him. So we don't know what further information he might be able to provide us. His employer says, it's clear he was driving a company van, but his employer says no, didn't have permission to drive. And what we have from Mr. Gabriel is his statement to the police that he was going to a job.
But that statement is not admissible. I mean, it's clearly hearsay.
Well, it is hearsay because it's an out-of-court statement. However, I believe under the residual exception, it would be admissible. It's got sufficient guarantees of trustworthiness. It was made to a police officer, and it's more probative on the point than any other evidence we have because Mr. Gabriel we can't find.
It's more it is more probative than the evidence that would indicate that he lived in Chandler. He there was no record of any job in Tucson that day, nor was there any record that he had been sent to Tucson that day. Isn't that right? Sure. Isn't that what the business records indicate?
Sure, but the probativeness here is the specific evidence itself. On this particular point as to what he was doing, this is the most probative evidence that we have been able to find to support the proposition that he was driving with permission. Now, it's a bit ambiguous, of course, if all the police officer recorded was that he was going to a job. That's what he said. Unfortunately or not, a police officer didn't query him to say, well, where was the job? Was it close by? Were you in a hurry to get there? What time did you have to get there? Nothing like that. All we have is he was going to a job. But on that particular point, that's the most probative evidence that we have. We can't find anything else. Now, there's a bunch of evidence stacked on the other side. His employer swears, well, no, he didn't have permission. He did work normally up in this area.
Well, he had never worked in Tucson, right? Is there any evidence at all that he had worked in Tucson?
I don't think there's anything in the record that I can recall, Your Honor. However, the company did do work down in Tucson and occasionally did send people down to Tucson, although apparently had somebody in that general area.
It said they assert that they had somebody in that general area. So when he said, I was on my way to a job is pretty ambiguous.
Yes, it is.
In that context. It doesn't say I was on a job for my employer, I was on a job for myself, I was just on my way to the store. Yes,
he said he was going to a job. It's ambiguous as all get out. However, it's up to the jury to decide what it means. What inference do we give to this? He was going to a job for a friend or just moonlighting, or he was going to a job for his employer. What inference we take...
Well, that assumes it's even admissible.
Yes. If it's not admissible, I'm standing on my knees right now because my legs have just been chopped off.
Well, isn't there an additional hurdle in terms of how it relates to the insurance coverage? I mean, it seems like there may be some question as to liability with Western, with the owner of the vehicle, and that they may have authorized people to take vehicles home or go somewhere not on a job-related business. But if it's how does that relate to whether there's insurance coverage? If you would agree that, sorry for the long long-winded question, but you would agree that the insurance company can say, we will only insure if you're going directly to a job and not going anywhere else, and van owner, you have to obtain other insurance for driving to your house, and you wouldn't have any claim against them, right?
I suppose not. If I can boil that down, the issue is really, did he have permission to drive? It's an issue that matters for the tort lawsuit, which is where it first came up. And the first judge said, we're going to let this go to the jury. And
But
then it's an
wasn't
issue.
that a completely separate issue? I mean, you're talking about respondent superior, that kind of thing in that context, in the negligence case. This is just simply, under contract, are you an insured? It's a different question, don't you think?
No, Your Honor, I think it's, as Fred Astaire would say, it's a potato question. What we've got here is, and my colleague has said, well, what we were doing in the tort lawsuit is scope and course of employment, and what we're doing in this lawsuit is permission to drive. It's the same thing. If he has permission to drive, he's driving in the scope and course of his employment. If he doesn't have permission to drive, he's not. So we're dealing with the same issue. And the issue is, if he doesn't have permission to drive under the insurance policy, I believe he would be outside scope and course, and there'd be no insurance coverage for him, which means his employer on the insurance, which means that Secura is out the door. It doesn't have to indemnify or defend him. There's huge ramifications, of course, in the tort lawsuit, and I'm sure that Secura's funded lawyers will get around to this. You know, if you get an agent out the door, you get some very interesting issues, especially in the light of developing Supreme Court case law, as to whether the principal is now out the door because the agent can't be sued. So I really don't know what's going to happen in the tort case. But I do know the tort case did deal, I believe, with the same substantive issue. And then when that didn't work out, the next thing we get is Secura bringing its own lawsuit. Of course, Secura was in the background of the first case. It funded, selected, retained the lawyers that brought that original.
But they're not a
motion.
party, and they do have a different issue. Coverage is a different issue than negligence.
Well, yeah, coverage is a different issue than negligence, but the underlying issue in both is the same. If you don't have permission to drive, there's no coverage, and there's no negligence on the part of the employer. And if the employee's out the door,
Couldn't there be a situation where the employer has let people drive without permission in the past? Would that maybe somehow create some liability for the employer?
yeah, possibly.
And that would be a different issue than, but he didn't have express permission, and the insurance contract says you only get to do it if we're only covering if you have permission, you've given someone permission to drive. So then the van owner would be on the hook by themselves and not have coverage. But that seems different than, is there coverage? And if there really isn't a dispute about permission, then it seems like you don't have coverage.
I think I see your point. The difficulty, of course, if we ever get back to the tort case, is Gabriel's gone. We tried to get a default judgment against him in the underlying tort case, and I'm not sure what's going to happen with that.
But what
If
keeps
the
you
case
from
goes
going back
forward.
to the underlying tort case? How does this ruling prevent you from litigating the tort case?
Well, if there's I'm not sure. If there's a determination here that he's not in the scope and course of his employment and he doesn't have permission, that's going to impact heavily, I believe, in the tort case. I think they'll figure out a way to try to use it against us in the tort case and say, well, it's res judicata, it's decided, it's collateral estoppel, and all the other brilliant theories that defense lawyers come up with.
Mr. Abney, I'd like to ask you a couple procedural questions just to make sure I understand. When Secura filed their action, did you move to consolidate it with the negligent case?
No, we regarded it as a separate thing.
Well, I would have thought you would want to consolidate it since you got a favorable ruling in the negligence case.
I wasn't involved at the point at that time, but
That was the
might
legal
not have
you.
been
It wasn't
like-
you personally. I'm
Oh.
assuming your client would have done that.
I think that sounds like an interesting idea.
I mean, was there anything that would have prevented you from filing a motion to consolidate the two cases?
Other than the Fred Astaire problem, because I'm not sure that's the same sort of thing. A declaratory judgment and the tort lawsuit combined in one.
Well, you're arguing there was some type of horizontal appeal in this case, and I was just wondering if that's true, then why didn't you move it for consolidation if you thought the trial court was ultimately going to have to make the determination on the same issue?
But as you know, when you get in this sort of situation, insurance always becomes a big problem in tort cases. So you'd have the insurance company as a party in the tort case, and the jury knows about it. I'm not sure
Well, if you
consolidation
can-
would be allowed.
Well, you could consolidate it for the limited purpose of the ruling on the coverage. I mean, that's all Secura wanted at this point in time is a declaration of coverage, right?
Well, yeah, well, the interesting thing about that and I think you started off with the interesting thing about that, that'd be stuck with the ruling for the original judge. Yeah, would have been a clever idea. I wish you were on the team there, Judge.
And I assume from your statement earlier that there was no reason to move to continue for discovery on the motion for summary judgment because Gabriel's just taken off and he's gone.
Yes, sir.
Okay.
I mean, I suppose they could have, and I don't think they did, you could have tried deposing the police officer. The trouble is police officers deal with so many accidents that the only thing that really triggers any memory of them is the police report, usually. And the police report is very bare bones. I don't know what could have really been discovered at that point.
And as we've been talking, I looked at my notes, and I have in my notes that you did not raise the residual issue as the hearsay requirement. Not you, your client did not raise the residual issue before the trial court on the admissibility of this statement by Gabriel to the police.
Possibly not. However,
Is that another hurdle that we have to get over to grant you relief?
it may be. Then again, it was discussed on appeal in the reply brief, definitely, which is.
I'm not saying you didn't raise it here. I'm just asking if you
Good.
I
I'm
wonder
glad
if my
I-
notes
glad
were
I did something
incorrect.
right. But I assume that the court can, if it wants to, look at this, and you have it, you're reviewing this de novo, and can say that, yes, it's not just an admission by a party opponent, which I believe it is. It also falls under the residual exception.
How can we really argue it's an admission by the party opponent? I am reading the decision by Judge Kiley, and it makes sense to me. He's a co-defendant, could be admissible against the plaintiff. I mean, what he says is basically Gabriel said something. Gabriel is not a party to the deck action. He is a co-defendant. Do you see what I'm saying? Gabriel admits something as a defendant in the deck action. He is with your client in the deck action as a defendant, so the admission can't
Right.
go against the insurance company. They're the party's opponent in this case.
Right.
Did that make more sense?
I think.
I hope.
But Gabriel was a party.
In the negligence action, this is a
It was a
deck
party-
action about coverage.
He was a party to the declaratory judgment action as well. He doesn't appear in the appeal because it was Megan who's appealing, but he was a party in the deck action.
As a defendant.
Right, which means who's on the other side there? It's Secura. So as far as Secura and Gabriel are concerned, this is an admission by a party opponent. He is a party opponent to Secura. I don't think it matters who the party opponent is. It is an admission by a party opponent.
It doesn't matter when the parties have different interests. That Gabriel might very well want to have coverage, but that doesn't mean he can say something that binds the insurance company, does it?
No, I'm not saying that it binds the insurance
But
company.
how can it be a statement against interest or by a party opponent if his interests are different than those of the insurance company?
Well, that's what makes him a party opponent. The
Yeah,
insurance
but we're
company is
talking
saying,
about, he's not the one who's seeking to have this admitted. It's someone else who's seeking to have his statement to be admitted against the insurance company.
yes, but I still think Gabriel is a party opponent. Secura is his opponent party. Secura doesn't want him
He's
saying
not,
that
he's not an agent of Secura.
No, it's not in the sense, no, and I'm not saying that it's a statement binding Secura.
So just anybody who's in the lawsuit, even though they have widely divergent views, the statement can be admitted against a party that has very different interests, just because this is one defendant in a lawsuit, it becomes relevant for all issues?
It becomes relevant in the sense of evidence, and I'm not saying that what he's saying binds Secura in any means. He's not an employee of Secura. He's not an agent of Secura. But he was a party to the deck action. Secura is a party to the deck action. They're opponents. Secura is saying, well, you didn't have any permission to drive, and where Gabriel hears, he might say, I was going to a job, and I did have permission to drive. We don't know exactly what he's going to say, but he's certainly a party opponent. Secura is trying to cut him out from any coverage. So they do have opposing interests. He's a party, they're a party, he's a party opponent.
I guess I'm just not following the logic. If he's not an opponent in terms of coverage as it relates to your client, Gabriel's not. He doesn't necessarily have. He clearly has different interests than the insurance company.
Well, he also has different interests from Megan. Megan's saying you're a crummy driver and you injured me. And so, I mean, they have conflicting interests as well.
Right, but that's what you litigate, whether he was a crummy driver and caused the injury.
Well, in a tort lawsuit, but here when we talk about the deck action, the central question is he a party opponent to somebody? And he is. And the somebody is very important because it's Secura. And Secura is the one that's saying.
But you're the party opponent would be if you were admitting the evidence against Gabriel, which, okay, you can admit the evidence against Gabriel, but why can you admit the evidence against Secura?
Because Secura is a party opponent to Gabriel. Secura is trying to say, Gabriel, you have no coverage.
So if
you have no
that were
permission to
true,
drive.
we've got this triad. We've got Secura up here, Western's
Right.
over here. We've got your client, we've got Gabriel. If we
Yes.
removed your client,
Yes.
it doesn't matter if Gabriel has coverage because your client is the one with the claim for negligence in this action. Do you see what I'm saying?
I do.
They're co-defendants. Both your client and Gabriel, allegedly, although we don't know, want Secura to cover this accident.
Yes.
You remove Gabriel from the accident, there is an accident. You remove your client from the accident, there's no damages. I mean, their interests are aligned in this circumstance and are adverse in the other circumstance. But this is a contract action to determine whether or not there's coverage, is it not?
Well, it's a declaratory judgment action, sure.
And so if their interests are aligned, they're co-defendants.
Yes, but for purposes of evidence, who is the party opponent to Secura? Well, it's Gabriel. And therefore his statement, which, that I was going to a job, would be admissible against Secura because that is the party opponent.
Maybe if he's their agent, but if there's no suggestion that he's an agent of Secura, that seems like a stretch.
No, he's not. Of course not. He's an agent of Western States is what he is. And Western States happens to be the insured for Secura. There's no quibbling about that. But he is a party opponent to Secura. And trying to get this admitted against Secura is the whole point here. I made some other arguments in the appeal, standing, statute of limitations, latches. I'd like to rest on what I put in the brief. I think it's more eloquent than anything I'd say this morning.
Well,
Unless there are any questions.
I do want to ask you just quickly about when is a declaratory action, when is the statute of limitations start to run? When's the triggering event?
I think it starts when you know or should know that there is some event or issue that needs to be resolved by declaratory judgment.
Why isn't it when there's actually a judgment entered against? When somebody actually tries to collect on the insurance, as in they file a claim with the insurance company.
Well, that could be one point, but if you know in advance of that there is an issue that needs to be resolved by declaratory judgment and you don't do anything, I believe it starts at the point where you know or should know that there is an issue that needs to be resolved.
But isn't that as between the insurance company and the insured? Doesn't that just have to do with the contract between the insurance company and the insured? And why wouldn't that just be a 6-year statute of limitations?
Well,
whether it triggers when they know there might be coverage, or you just wait until there's a judgment against them. Why don't they have 6 years after? Why wouldn't it be the 6-year statute of limitations if we're going to impose one?
If this were a breach of contract action, I suppose it would be, but this is not a breach of contract action. This is an action to determine coverage, and it would be triggered.
But isn't that only, you only have a deck action because you have a contract? And so
Sure.
you're saying you have to comply with this contract. And they're coming in ahead of time and saying, we don't have to comply. This contract does not govern here. So isn't it at the end of the day, it would be a contract matter if you just got a judgment against the van company and then they want coverage from their insurer, they could sue the insurer, and it seems like there would be a 6-year statute of limitations for them to go after them. We have a contract, you've got to reimburse us for this judgment.
Well, there is no statute of limitations specified for a declaratory judgment action. You pull up the appropriate statute of limitations. In this particular case, since this is, from Megan's perspective, this is an action that arises out of the events of the accident, and at a certain point in the arc there, it has become apparent to Secura that there's going to be a dispute about coverage. That would trigger a 2-year statute of limitations because it's a tort action is the underlying action.
What's your best authority for that?
The ones I provided in a brief, Your Honor. I cited a few cases on it. If I may reserve my remaining 25 seconds.
All right. Thank you, Mr. Abney.
Or 22 seconds.
I'll give you.
No, they have to give it to me. Thank you, though.
Good morning, Your Honors. My name is Christopher Robbins. I'm here on behalf of Secura Supreme Insurance Company. I really don't have a lot to add. Judge McMurdy, you asked about consolidating the cases. We've often been turned away by trial judges saying, "No, I'm not going to mess up my tort case with your coverage case, and I'm not going to get insurance involved." So we've been told that by trial judges that they will not consolidate those type of cases. And obviously there was no even attempt here. And in any event,
Doesn't it seem odd, and it's neither here nor there, but doesn't it seem odd that we're having two different judges rule on basically the same facts?
they're
It
similar.
just doesn't seem like
they
it's-
are very similar facts, Your Honor, but they are completely different issues. And
Oh,
that's
I don't disagree with you. I'm just saying that
Yeah.
you're
see.
asking two different trial judges to review the same police report, the same business records, the same everything else. It just seems like a horrible way to run a railroad.
Maybe you consolidate things for discovery. I don't know. But again, nobody's heard from Mr. Gabriel since 2016. My client was actually, Randy Williams, the owner and managing member of Western States, was actually a friend and gave him the job and knew what a good employee he was. And he hasn't been able to contact him for 4 years. We don't know whatever happened to him. As Mr. Abney pointed out, we've both had investigators attempt to find him and have been unable to.
Was there a default judgment entered against Mr. Gabriel in the negligence action?
No, this is exactly what triggered the declaratory relief action, Your Honor. Gabriel never tendered the defense to Secura, so Secura had no reason to do anything. It has always defended, and it will indemnify its insured Western States unconditionally. There's no question about that. It has always done that. Once they moved to default Mr. Gabriel, this is what Secura did. It did two things. First, it intervened in the tort action to assert a defense on behalf of Mr. Gabriel to protect its insured Western States, and at the same time filed this declaratory relief action. And that's why, Kepner versus Western Fire says basically you can file a DEC action to determine insurance coverage at any time, before, during, after, any time. No other case law matters because that case is definitive from the Arizona Supreme
When
Court.
intervening, so you're saying it's still impractical and the Superior Court judge doesn't want the insurance company to file pleadings relating to the insurance contract if they've intervened?
Exactly. We intervened to assert a defense under a reservation of rights on behalf of Mr. Gabriel. In other words, so they can't default Mr. Gabriel and say, he's liable, in Western States, you're now liable. That was the purpose of that. They never raised any exceptions to the hearsay argument. Mr. Abney did participate in the oral argument in the trial court. He mentioned something. Judge Kiley addressed, I think, thoroughly and very reasonably the argument that was made there that it was an admission of a party opponent. Judge Campbell, you're exactly right. They're down here. You don't somehow get up to the plaintiff under that exception. And then the residual exceptions, those were never raised until the reply brief. Those were waived.
If you had to address it, how would you address it?
I-
If it wasn't waived?
I would have to go through the rule, Your Honor. In fact, I did look at it yesterday, obviously, in preparation. It just doesn't fit in there. And it is not the most probative evidence, because the most probative evidence of what was happening down there is Randy Williams' declaration that there were no jobs down there.
In Tucson.
In Tucson. There were no jobs down there that weekend. They would never send Mr. Gabriel down there alone to do a job because they had a person down there who could do it. Mr. Gabriel never worked in that area. It was his day off. He was not on call. Even just little things like sweating profusely. Well, he was sweating profusely, according to the officer, we suspect, because he knew he should not have been down there in the company van. And the bottom line is, if he was going to a job site, it absolutely positively was not a job site for Western States. And the only way he could have permission to drive the vehicle was if he was going to or from work for Western States.
What if Western States just had a policy of allowing their employees to, essentially if Western States ignored the written policy and had a history of allowing employees to drive the vans and even take them out of town on the weekends?
Yeah, I understand what, and that goes to the case law on implied consent, and that, Universal Underwriters talks about if there's a regular course of conduct, if this is something that's happened for a long time with this employee, but there's zero evidence that it happened before, that it was any sort of regular course of conduct. These are big, they put the photo of the van. These are big, expensive vans. You don't want your employees driving them around for pleasure, for personal use, and especially you don't want them driving around to do somebody else's business. And then, even if you got through that step, then you talk about, well, was this a major or minor deviation from the implied permission? And this was certainly a major substantial deviation when he's not supposed to be driving at all, let alone in Tucson, let alone on his day off.
But if he's just in Chandler or wherever he lives and he just takes the van to go to the grocery store, he's gone home and he goes to the grocery store, under the policy, would there be coverage?
I don't think so, Your Honor, because that would, unless,
Would that go?
for example, if he stopped at a grocery store on his way to or from work, then it's a closer question. And then it might even be a question of fact for the jury. In this case, he's not around. There's only one person who's given material admissible evidence in this case, and that's the boss, the owner and managing member of the company, who said absolutely no, he did not have permission to be driving on this date, at this time, at this place.
And they could presumably conduct discovery and ask other employees if they were given permission to, or used company vehicles for other things other than going to a job.
No, because this is, Judge Kiley pointed this out in the minute entry, and in the minute entry ruling, and Your Honors, I can't do any better than he did. He wrote a Court of Appeals decision in this 6-page, single-spaced minute entry. But first of all, there was no other evidence of that, and second of all, it has to be this particular employee there's zero evidence that this particular employee had ever done it before. And so there's no regular course of conduct that preceded the day of the accident. And here's, one of your honors asked about, well, what happens now? You say he did not have permission, he was not insured. The tort case can go on. It can go on against Gabriel, although he's not insured now. It can go on against Western States, and Western States is insured and will be indemnified, and is being defended and will be indemnified by Secura if it's found to be liable.
What's the theory of liability if they didn't give permission to drive the vehicle?
That he was acting within the course and scope of his employment.
But you're saying there was zero evidence of that?
Well, the judge in the underlying tort case, we don't know how, but he found a question of fact. We don't know what that question of fact was because his mid-entry ruling on the motion for summary judgment on course and scope was motion denied, period. We don't know. Maybe he found the statement in the police report. We don't know. I can't explain why the judge ruled in that case the way he did. But you can imagine, for example, you can imagine that that doing one of the things that you said, that Gabriel did have permission to drive the van because he had done it so many times before and he was just going to a store or something. And yet he would not be in the course and scope of his employment so that Western States would be vicariously liable under respondeat superior. It would just be Gabriel. If he did not have permission to drive at all, I'm speculating here, but I think there might be a strong argument that he couldn't have been acting in the course and scope of his employment. But I don't know. That's something that will need to be decided by the trial judge in the tort action.
Can you give me your best argument against Mr. Abney's argument that the statute of limitations should be when you knew or should have known? We have the case law that says deck action anytime.
Exactly.
Anything else? Why is that an unworkable situation if we were to adopt that as know or should have known? As the triggering event.
I think what he was talking about, what the case law talks about is when could the insurance company first file a deck action? And there might be a trigger point. It might have been much earlier. But Kepner says you can decide, you can resolve it right then, or as one of your honors pointed out, wait for the judgment. Wait for a judgment until Secura knows that it might actually be liable for something. File the deck action then. I think Kepner was a garnishment action. I'm trying to remember correctly, but after a judgment. The cases that he's citing, this is the way I understand the cases he's citing. It's saying, for example, if Ms. Sudhoff, who is suing for damages in the underlying tort action, missed the statute of limitations and is barred from pursuing the tort claim, she cannot then file a deck action saying, you know what, I want I want you to declare that I was injured and I had suffered damages. She can't do that. The cases that he cited, and I think we referred to this in our answering brief, is Secura is basically asserting a defense. And so as long as she timely files her tort action, we can assert the defense that Gabriel was not insured, and though she can continue to pursue her action against Gabriel, he's not insured by Secura on the Western States. That's the way I read the case law. And it was somewhat confusing, but the bottom line is this court has said in a couple of cases there is no statute of limitations for declaratory relief action. And I don't think there's any reason to change that law in this case.
It would actually be the if there's a judgment against Western States and they thought they had coverage, they would have the 6-year statute of limitations to try to seek coverage, and this is just, it's a defense for the insurance company at that point. So there's no reason for them to ever, there's no need for a statute of limitations for a deck action. from there.
Exactly. Yes. And let me just finish. Mr. Abney talks about inferences that can be made, assuming that the hearsay statement in the police report was admissible, inferences that can be made. Well, presumptions and inferences always are preempted by direct evidence. And again, the only direct admissible evidence in this case is from Mr. Williams, who said he absolutely did not have permission express or implied. Thank you, Your Honors, unless you have further questions.
All right, thank you, Mr. Rowett. Mr. Abney,
Does my time start when I start talking?
it already did.
Oh, my God. Okay. As I learned from watching Perry Mason, there's very few, the only thing that really has no statute of limitations is first-degree murder. Almost everything else has got a statute of limitations. And it makes sense that in a declaratory judgment action, you'd have a period of time where you have to get it done. And it starts under the Rogers versus Board of Regents case when when something goes through the realm of mere possibility and creates an actual controversy. I'm out of time.
All right, thank you very much, Mr.
Thank you very
Abney.
much.
The matter is deemed submitted. We'll issue a decision in due course. Thank you for your argument and your briefs. Court stands in recess.